Hi and Assalamualaikum. My name is Nur Adla binti Zais. I will present to you a slide of introduction and summary of the case. In Malaysia, employer and employee relationship are controlled by labour law, especially the Industrial Relations Act 1967 under Section 20. If a worker feels he was dismissed unfairly, he can bring the case to the industrial court. For constructive dismissal, the worker must prove that the employer seriously broke the contract and left him with no choice but to resign. In this case, Adnan bin Yusuf made a claim against Empire Manufacturing Sdn Berhad. The question is whether the disciplinary action by the employer forced him to resign. Alright, next I will briefly summarize the case to you. The claimant, Adnan bin Yusuf, was working as a supervisor and earned 2,600 ringgit per month. On 29 July 2020, a female employee accused him of sexual harassment. She said he stood too close to her, spoke in a way that made her uncomfortable, tried to take her picture without permission, and also sent her a WhatsApp message inviting her to Pizza Hut. The company then started an investigation. They reviewed the CCTV footage and interviewed other employees. After that, he received a show cause letter and was suspended. Although he bring his explanation, the company decided to proceed with a domestic inquiry. During the inquiry, Adnan was present and even bring witness. After examining the evidence, the panel found that the misconduct was proven. The company later demoted him, reduced his salary, and withdrew part of his allowance. He was unhappy with the decision, so he resigned and claimed constructive dismissal. However, the court found that the inquiry was carried out fairly. He had the opportunity to defend himself, and the company had the right to decide the punishment because there was no fundamental breach of contract. His claim was dismissed.
Hi and Assalamualaikum. My name is Irel binti Muhammad. This slide I want to present about three issues in this case. First issue is whether the claimant was a constructive dismiss, which is Adnan bin Osup had been constructively dismissed by Empire Manufacturing Sdn Berhad. The claimant argued that the company fundamentally breached his contract by demoting him, reducing his salary by 300 ringgit, and withdrawing his 65 ringgit allowance. He claimed the action were unfair and forced him to resign. However, the company argued that the resign by a voluntary. It stated that the demotion and salary reduction were a disciplinary action after a proper domestic inquiry. Therefore, the court had to decide whether the company action amounted to a fundamental breach of contract that justified constructive dismissal. Second issue was whether the domestic inquiry followed the principle of natural justice, which is whether company handled the sexual harassment complaint filed against the claimant on July 29, 2020, in accordance with the proper procedure and the principle of natural justice. The claimant argued that the inquiry was biased and unfair, even though he received a show cause letter with a false charge. However, the company conducted an investigation, reviewed CCTV, interviewed witnesses, and held a domestic inquiry where the claimant was present allowed to defend himself. The court found that he was given proper notice and a fair opportunity to be heard, so that the inquiry was conducted with a fairly. The last issue is whether the disciplinary punishment was reasonable and fair, which is whether the company disciplinary punishment was reasonable and fair given the misconduct established during the domestic inquiry. The claimant argued that even if misconduct was proven, that the management imposed a heavier penalty than what the domestic inquiry panel had just suggested. However, the company argued that management has the final authority to decide on opportunity disciplinary action, especially in serious cases like sexual harassment. The court argued with the company. It held that an employer is not strict bound by a panel recommendation as long as the decision is made in good faith and is not arbitrary. After review the evidence, the court concluded that the punishment was reasonable and justified, so that there was no breach of contract and no contractual dismissal. Thank you. The next presenter.
This slide explains how the case relates to relevant Malaysian employment law. Under Section 20 of the Industrial Relations Act 1967, the court must first determine whether a dismissal actually occurred before deciding whether it was without just cause or excuse. And in this case, the burden was on the employee to prove that he had been dismissed. In assessing constructive dismissal, Malaysian courts apply the contract test, which requires proof of a fundamental breach going to the root of the contract. Although the claimant was demoted and experienced a salary reduction, the court found that this action followed a proper domestic inquiry and therefore did not amount to a fundamental breach. This case is also linked to Part XVA Section 81A to 81H of the Employment Act 1955 on sexual harassment, where employers have a statutory duty to investigate complaint, and here the company comply by conducting an investigation, issuing a showcase letter and holding a domestic inquiry. The principle of natural justice was observed because the claimant was informed of the charge and given the opportunity to defend himself and present witnesses. In conclusion, the court held that the disciplinary process was fair. The employer acted within its contractual and statutory rights, and the claimant failed to prove constructive dismissal, resulting in the dismissal of his claim.
Hi, my name is Nabila binti Zaidi. My number matric is 4241000351. I will explain the strength of the company position in this case. First, the company followed proper disciplinary procedure. They did not immediately punish the employee after receiving the complaint. Instead, they issued a show cause letter explaining the allegation. This gave the employee a fair opportunity to understand the sanction and prepare a defense. In employment law, procedural fairness is very important because every employee has the right to be heard before any action is taken. Next, the company conducted a domestic inquiry or DI. During the inquiry, the employee was allowed to attend, explain his side of the story, and bring witnesses to support him. The company also presented CCTV footage as evidence. This showed that the company relied on proper evidence and did not act based on assumption. Court usually emphasize whether a proper inquiry was conducted before disciplinary action is imposed. Since the company followed this process, it strengthened their legal position. Another important point is managerial prerogative. Employees have the right to manage and discipline employees if misconduct is proven. Although the DI panel recommended a lighter punishment, the final decision belongs to management as long as the punishment is reasonable and supported by evidence. The employer have that authority to decide the appropriate action. In this case, the misconduct involved sexual harassment, which is considered a serious workplace offence. Employees have a responsibility to ensure a safe working environment. Taking firm action help protect the other employees and maintain workplace disciplines. Therefore, the demotion and salary reduction may be justified. Lastly, it's not clear evidence that the employee was forced to resign. The resignation letter only showed dissatisfaction, but there was no proof of threat or assertion. In constructive dismissal cases, the employee must prove that the employee committed a serious breach of contract. In this situation, that was not clearly proven. In conclusion, the company followed proper procedure, relied on evidence, acted with its authority, and there was no strong proof of forced resignation. Therefore, the company has a strong defense against the claim. Now I will explain the weakness of the company action. Although the company may be legally correct, there are some concerns about how the punishment was imposed. The main issue is proportionality. This means the punishment should match the seriousness of the misconduct. In this case, the domestic inquiry panel only recommended a short suspicions. However, management decided to impose a much heavier punishment, including demotion, salary reduction, and withdrawal of allowance. This big difference may make the punishment look excessive. Salary is important part of employment contract. When salary is reduced, it rarely affects the employee's financial stability and livelihood. Demotion can also damage the employee reputation and professional image. When both income and position are affected, at the same time, it may have a long-term effect of the employee career. Even though management have the authority to decide, the punishment and decision must still be reasonable and fair. Another weakness is the perception of unfairness when management ignores the DI panel recommendation and impose a much harsher penalty. Employee may feel that the inquiry process was just a formality. This could reduce trust in the company disciplinary system. In any organization, trust, transparency, and fairness are very important. If employees feel that decisions are unpredictable or too harsh, it may affect morale and confidence. There is also a concern about evidence. Although CCTV footage and statements were presented during the domestic inquiry, the complainant did not testify directly in court. This may raise questions about whether the employee had a full opportunity to challenge the allegation. Cross-examination is important to test the credibility of evidence. Without a direct testimony, the fairness of the process may be questioned. Furthermore, the combination of demotion and salary reduction may create a stressful or uncomfortable working environment. Even if the company did not force the employee to resign, the severity of the punishment could indirectly persuade him to leave. In constructive dismissal case, court looks at whether the employee action destroy trust and confidence. A harsh punishment may damage the relationship. Lastly, the company could have considered alternative actions such as counseling, sensitive training, or a temporary suspension. This option could have addressed the misconduct while maintaining fairness and preserving the employee relationship. By choosing a heavier punishment, the company increased the risk of legal challenge. In conclusion, although the company followed proper procedure, there are weaknesses related to proportionality, fairness, evidence, and trust. This case shows the employer must carefully balance discipline with fairness.
For this slide, I will explain several solutions to overcome repeating dismissal issue by strengthening internal governance and disciplinary practices. First, under workplace policies, the organization should establish a clear anti-sexual harassment policy that defines misconduct, reporting channel, and confidentiality protection. A well-structured policy helps employees understand acceptable workplace behavior and allow management to handle complaints consistently. At the same time, clear policies also reduce uncertainty and prevent disciplinary mismanagement that could lead to industrial court dispute. Next, in fair disciplinary procedure, disciplinary action must follow a standardized and transparent process. This includes issuing formal written allegation, allowing employees sufficient time to respond, and conducting a fair domestic inquiry before any decision is made. Applying the principle of natural justice ensure that decisions remain reasonable and less vulnerable to legal challenges, even when misconduct has occurred. Moving to sensitive case handling, employers need to consider exceptional situations such as medical incapacity. When an employee is unfit to participate, the organization should obtain medical confirmation and consider postponement or authorized representation. Humane and balanced decision-making help avoid claims of unfair or unreasonable treatment. Lastly, under training, documentation, and governance, continuous managerial training is important so that supervisors understand misconduct handling and their legal responsibility. Proper record keeping of complaint, investigation, and disciplinary decision also strengthen transparency and provide strong evidence if dispute arise. Overall, this solution help organizations exercise managerial prerogative responsibly while maintaining procedural fairness and long-term industrial harmony.